How's it going? My name is Seward, and I'm an attorney that specializes in P1, O1, and EB1A visas for some of the best athletes, entertainers, and professionals in the world in the extra ability visa categories. And at this time, we're talking about something that comes up a lot with people that want to transition to permanent residence, a green card, in the United States under the EB1A category. The EB1A category is very attractive to people that have a lot of accomplishments because they don't need a job offer and they also don't need to be sponsored in order to use this category to get permanent residence. But the thing to know is that it's one track to be on an immigrant path, which means it comes with a green card, and it's another track to be on your non-immigrant part, which just comes with work authorization. In this particular circumstance, we would have a student that's on F1, but also happens to be a bad man when it comes to being a race car driver, having won multiple international championships and has been ranked in the top of the world 3 times when it comes to motorsports. So the question is, can they transition directly to the EB1A? And the answer is yes, it is possible, but it's risky. Why? Because if you apply for the EB1A, everything is fine if it gets approved, but we highly recommend that anyone pursuing the EB1A also pursue a non-immigrant track, even do the non-immigrant track first, just so if there's something that happens with the EB1A process that they are not accruing unlawful presence, because the EB1A doesn't come with lawful presence. You have to kind of wait until you get approved for that to come through and be fine, or even with your work authorization. For that reason, we always advocate that somebody that is in the country, in the United States, and wants to stay, apply for an O1 first, because we can do it to where you get a lot of the same work authorization, but you also have none of the risk of something going wrong with the EB1A. Now, we are not saying that a person that's good for an O1A is not always good for an EB1A. The thing is, as responsible attorneys, we know that we're not the ones that press the button. And sometimes you get officers that don't know what they're doing, and you get officers that are having a bad day. But we do not want that to affect the full life of somebody being able to enjoy themselves with work authorization or permanent residence in the United States. That's the reason why we advocate get the O1A visa first, or the O1B, depending on your acumen, your accomplishments, and history. And then when it's settled and all set, then work on your EB1A application. A lot of times we're willing to do a discount on the EB1A because the arguments we make for both are very similar, but that goes on a case-by-case basis. But that is the most responsible way to pursue this situation where you're graduating on an F1, want to go to EB1A, but you are going to stay in the United States. It's best to go for that O1A first, because it will keep you in status regardless of the impact as a result of the EB1A. And it also lets you know where you are as far as how strong your arguments are, because the O1A and the EB1A have very similar arguments, but it's just the EB1A tends to be adjudicated more strictly. So if you can get an O1A, you know that you're very on a great path on being eligible for the EB1A. And I hope that's helpful for all you motorsports drivers and athletes out there. Appreciate you guys.